Mr. Mchizana, I apologize, Your Worship. Your Worship, this is the first appearance in this court. The charges are as per the charge sheet. The state and defense agree that the matter for bail ought to be heard in terms of Schedule 6 based on the type of charges that the accused is facing, particularly in respect of count 1, which is a contravention of Section 14 of the Pacta Dada, or the Protection of Constitutional Democracy Against Terrorist and Related Activities Act 33 of 2004. The state is not opposed to bail.
Just one moment before you proceed. Mr. Duduzile Zuma, you may be seated now. Sorry, Mr. Gaten, you may proceed.
Thank you, Your Worship. The state is not opposed to bail in this matter. The bail is to be heard in terms of Schedule 6, as I have explained to Your Worship.
Yes, the reasons as you are obliged to place on record for non-opposition is here.
Your Worship, we have verified.
Sorry, do you not want to deal with the issue of the televising of the proceedings?
Indeed, Your Worship. I think that there was an application brought.
Yes. Mr. Nkoku, have you had sight of this application? It's a very terse application.
No, I haven't, Your Worship, but if it's the standard one, then
This seems to be a standard one.
Yes.
Very generalized.
yes.
No objection from the state, Your Worship. We are.
Thank you.
We have no objections.
Just in respect of that application for the televising of court proceeding, what authority do I have to grant that? Just very briefly.
Your Worship, I would assume that it is in the discretion of the court. It has become a practice these days in all of our courts, including our superior courts. All right. And at the end of the day, we all subscribe to the view of an open justice system where justice must be seen to be done.
Thank you, Mr. Nkoku.
As God pleases, Your Worship, yes, no, we have no objection at all in respect of that application, and I agree with my learned friend that it's a matter of that is within the discretion of the court, and whatever conditions the court might place will be in the discretion of the court. But at this stage, we have no objection.
Thank you.
As God pleases, Your Worship.
Thank you, Mr. Nkoku. All right. Let me just make a reading on that. It seems that of recent, particularly, our high and higher courts have allowed the televising of court proceedings, particularly where these matters of great public importance or public interest. Insofar as it pertains to the lower court, that the magistrates court was governed by Rule 13 of the Code of Conduct, where magistrates were not allowed to allow, or we're not entitled to allow the televising or the taking of photographs in court proceedings. This persisted and continued to be under the Code of Conduct for Magistrates Court. Two of the important cases are Pandita's case by the SCA dealing with the televising of court proceedings, and before that the SABC Limited case in 2007 by the Constitutional Court. But both these courts dealt with the issue in the context of the exercising of the Section 173 power, which is only conferred to the high and higher court. However, I am in agreement with both parties that the Constitution provides for a fair public hearing. The media in all its forms should be entitled to convey to the public and have the proceedings televised. That also infuses public confidence in the justice system and transparency. It is on the basis of the values enshrined in the Constitution that I do indeed allow the proceedings to be televised. With regard to the qualifications, I will hear Mr. Judy and Mr. Nkoku on due course regarding the restriction of publication in any manner whatsoever. Thank you. Yes, you may proceed, Mr. Judy.
Your Worship, as I indicated earlier, the state is not opposed to bail.
Yes.
The reasons that we have decided not to oppose bail are the following. Your Worship, the address of the accused has been verified. It is recorded in the affidavits. The accused is an employed person, and we have verified the employment. More than that, Your Worship, the accused was aware of the investigation and made comment regarding it some 2 years ago, and is still available and cooperated fully with the state as far as being present in court is concerned today. Even though the accused appears, as it must be in terms of our law, in custody, I can place on record that she handed herself over willingly to the police this morning, and she was processed and brought into court for these proceedings to be held. And on that basis, Your Worship, we do not oppose bail.
Sorry.
We do not also consider her to be a flight risk.
Yeah, just one moment. You say that as she was supposed to in law appear before his court.
Your Worship, the accused is being arrested in terms of a charge that falls within Schedule 6, which gives the court a discretion regarding bail issues, which is why she has been brought after handing herself over to be before the court, so that the court can determine or make a proper determination on the bail issue, despite the fact that the state does not oppose.
So was the applicant then arrested? You understand?
Yes, she was arrested, Your Worship. She was placed under arrest this morning.
With a warrant or without a warrant?
Without a warrant, Your Worship. We contacted her through, I think it was through the political party officers at first, and then we got contact with her legal representatives, and arrangements were made for her to be brought in this morning, which she did, and she presented herself to the investigating officers who went through the process of having her and the matter placed in the court.
I asked that because it seems to me from your address there's a bit of conflation between the two processes. One deals with the arrest, which is a separate process, and then the issue of remittance on bail or otherwise, which is also a separate process, which is within the discretion of the court.
Your Worship, we did not want to deprive, if that is the word, the court of that discretion, which is why it is customary for us as the prosecution, when a person is charged in terms of Schedule 6, to place a person before a presiding officer in custody. For a presiding officer, as the law requires, to make the determination in the bail process as to whether the onus on an applicant in a Schedule 6 application has discharged the onus of presenting exceptional circumstances in the interest of justice. And it's a process thing that we have, and in the end it's Your Worship's discretion regarding bail. The state, as I indicated, is not opposed to bail in this matter. Further to that, Your Worship, we have assessed that the accused is not a flight risk, and the likelihood of any interference with witnesses is minimal. We have taken certain precautions regarding the witnesses, which gives us reason to believe that we do not have a fear in that regard as well. Those are my submissions regarding the non-imposition of bail.
Thank you, Mr. Liu. Do we require that to be interpreted, or is it fine?
No, we
don't require interpretation.
As the court assistant.
Thank you, Mr. Bowman.
Thank you, Your Worship. Yes, Your Worship, I confirm that I appear for the accused in this matter, instructed by my attorney, Ms. Tina Africa Mpumbana. Yes, I do confirm most of what my learned friend has informed the court. Indeed, my Lord, Your Worship, the arrangement is as was outlined by him, in that the investigating officer and I had the first contact, and then I also had contact with my learned friend. So the process that was followed this morning of the formal arrest, as it were, was done to that arrangement. Yeah. And now we have then come to this process. And to the extent that the matter is presented as a Schedule 6 offense, we also agree, Your Worship, that then shifts the onus to the applicant or accused, such as it were. And we therefore, with the direction of Your Worship, at the correct time would be in a position to read out the affidavit onto the record. Fortunately, the attitude of the state has already been outlined to the court, and therefore we would really just do it as a matter of formality for the record, as a court process.
Thank you, Mr.
In other words, Your Worship, sorry, Your Worship, then therefore the implications of that is that the matter would then falls under Section 60(11)(a) of the Criminal Procedure Act, as a court process.
Thank you. Thank you, Mr. Inkofu. And you've conceded the onus is on the applicant. Perhaps you could commence then.
As court process. Your Worship, I did hand up in chambers a copy of our application in terms of Section 60(11) bracket A of the Criminal Procedure Act 51 of 1977. If I may, Your Worship, can I just go to the affidavit before I go to the notice of motion?
Yes, certainly.
That's court process. Your Worship, also with your permission, if I may be permitted to leave out some of the personnel details, but obviously they are as reflected in the affidavit.
Yes,
As a court process. It reads as follows. I, the undersigned, Duduzile Zuma, Sambuga, do hereby make oath and state that I'm an adult female born on the dates that are outlined there. I'm the applicant in this application for bail pending my trial. Facts are within my personal knowledge unless stated otherwise, and that to the best of my belief true and correct. And I make submissions of law and do so on the advice of my legal representatives, whose advice I accept. And the content is as follows, Your Worship. We've, for the convenience of the court, put it in separate headings to deal with some of the requirements of the law. I'll start at paragraph 4 then. I have been charged with incitement to commit the offense of terrorism and incitement to commit the offense of public violence, the exact details of which are unknown to me, but I understand these charges and the seriousness of the same, and I intend to plead not guilty thereto. That is when the trial starts. 5. Although I have not yet sight of the complaint or the summary of facts, I'm aware of the long-standing rumors and innuendos about the messages which I sent from my social media accounts, mainly on the Twitter platform, in connection with the general uprising which had already erupted in KwaZulu-Natal, in the KwaZulu-Natal and Gauteng provinces, in reaction to my father's imprisonment in July 2021. Although I do not deny having sent some messages which have been misconstrued, I am of the strong opinion that no court can find that the violence in question occurred as a result or in connection with any incitement or any conduct on my part. The two things are utterly unconnected, causally or otherwise, in any sense envisaged in our criminal law. My conduct was only informed by my particular sense of outrage at the injustice meted out on my own father. This went much further than the objections of his political supporters and millions of other peace and justice-loving South Africans who, like me, did not participate in any acts of public violence, either directly or indirectly. I also hold the strong view that the charges are malicious and politically motivated. They are aimed at settling political scores with my father by the current regime. Evidence in this regard will be led during the trial. Suffice at this stage that I am confident that a case of malicious prosecution will be well and easily established against the National Prosecuting Authority at the appropriate stage. I have instructed my legal representatives to pursue that action. 9. It is plainly nonsensical and petty to interpret words which are used, such as, quote, I see you, unquote, to mean that the people referred to or were influenced by my social media commentary. The mere fact that it has taken the state almost 4 years to work out whether a small number of social media messages constitute, quote, terrorism, unquote, speaks for itself and is an indication that the NPA is clutching at straws with a very weak case. 11. I have been informed that the charges proffered against me constitute a Schedule 6 offense and that I bear the onus to prove on a balance of probabilities that there are circumstances, that there are exceptional circumstances, so that's what it should read, and that the interests of justice require that I be granted bail. Then the facts were placing before the court. In this regard, I wish to place the following facts before this court, this honorable court. I'm currently residing, I'll also limit the headings in as well, just for the record. Permanent residence, movable and immovable property. I'm currently residing at the address indicated there, where I have been residing for 13 years. The property belongs to the company that's mentioned there, a company owned by my estranged husband. I do not own any immovable properties in my own name. That place. I was born in Mozambique, in Maputo, and I am a South African citizen. My ancestral home is Kwata Junise, Ngandla, in the province of KwaZulu-Natal, where my father currently lives. And under the heading family, I am legally married but separated and live with my 2 children, namely, and then the names of the children and their ages are outlined there, Your Worship.
Yes.
Following the separation, I am the custodial parent and primary caregiver to my minor children. They both attend school in Johannesburg. Employment. I'm currently employed or engaged as a member of parliament in the National Assembly in Cape Town, having been duly elected as such in terms of the electoral laws of South Africa during the recent May 2024 elections. As a representative of the Umkhonto weSizwe Party, which is the official opposition party in South Africa. I'm also a duly elected member of the Pan-African Parliament, in which I am the Southern Caucasus chairperson responsible for the SADC region. My income from membership of the National Assembly and other business initiatives amounts to approximately the amount stated there on average. No, under the heading, no previous convictions or pending charges. I have been informed of the provisions of section 60, bracket 11, bracket A, and state that I have no previous convictions, nor is there any other pending case against me. No likelihood to endanger public safety or commit Schedule 1 offenses. I respectfully state that there is no likelihood that I will endanger the safety of the public or any particular person, nor will I commit a Schedule 1 offense should I be released on bail. The offenses for which I am charged were committed almost 4 years ago under specific, unprecedented circumstances which are unlikely ever to repeat themselves. Undertaking not to interfere with state witnesses, which my learned friend addressed. I will not make any contact with any state witnesses, nor have I attempted to do so. In fact, I'm not aware of the identities of any witnesses. I also understand that the major part of the evidence is based on transcripts or screenshots of social media messages rather than human witnesses, save possibly for expert and non-partisan witnesses. Any possible interference with such witnesses would be futile and senseless. No flight risk undertaken to stand trial. I respectfully state that should I be released on bail, I will stand my trial and that I do not constitute a flight risk. In this regard, I place the following on record. 1. This matter goes back as far as 4 years back. It has been lingering in the air for a long time. 2. I was fully aware of the fact that I'm being accused of instigating the well-known unrest and uprising which took place in July 2021, triggered by the widely perceived imprisonment of my father without standing trial. Many South Africans, rightly or wrongly, viewed that as an affront to our constitutional democracy and reminiscent of apartheid-style that seems to be misprint. It should read apartheid-style tactics. 3. Despite these allegations against me and knowing there was a high probability of a criminal case being investigated against me, I have always returned to South Africa. In the circumstances, I submit that the history of this matter clearly shows that I'm not a flight risk and that I will stand my trial in this matter. And then the worship will deal with the crucial matter of exceptional circumstances in terms of the section from paragraph 26 onwards. In addition to what is stated above, this matter also exhibits the following exceptional circumstances. 1. The evidence will probably be mainly led by experts. Should be an S at the end of it. 2. Unlike all other persons who have been labeled as alleged instigators, I have a blood relationship with my own father, whose imprisonment was arguably the spark of the incidents in question. It is hardly surprising or remarkable that I was aggrieved by his imprisonment. 3. I am an elected public representative of a political party voted by more than 2.3 million voters. 4. My incarceration pending the trial, whose duration and state of readiness is unknown, is unknown, would serve no purpose. 5. I have pledged to abide by my bail conditions. 6. To the best of my knowledge, no other person who has been charged with the same or similar offences has ever been convicted. Some have been either acquitted or have had their charges withdrawn. Then possible bail conditions and safeguards. I further submit that with adequate bail conditions, any fear in this regard by the state can be negated, including not leaving the country without notifying the investigating officer in this matter, which has been proposed by the state and agreed to by me. That we should fine. And then the affordable bail amount, paragraph 28. I am furthermore able to pay an amount of 3,000 rand for bail. This is in keeping with the amount of bail paid by other persons facing the same charges in relation to the same incidents, none of whom are members of the National Assembly until 2029, as I am. In the circumstances, I respectfully submit that the interests of justice require my release from incarceration, and it's signed, Your Worship, by the accused person, and it's dated yesterday, the 29th of May. As copies, if I may just then quickly go through the notice of motion is the usual preamble, and the order that is sought, Your Worship, is that the accused be released on bail pending the trial in the sum of 3,000 rand. and such conditions as the court deems fit, including the one that I mentioned. I'm indebted to the court. As the court is. If I may just check.
Yes, certainly.
As the court pleases.
Thank you, Mr.
Your Worship, I apologize for interrupting. There was an important oversight, and I think it's because we've waited so long for the proceedings to start. Before the accused is asked to confirm her statement, can she also be warned that any comments made in the statement may be used against her in a subsequent trial? Yes. As the court, I just thought that we had forgotten because non-practice to remind the court.
Thank you, Mr. Ms. Zuma Sambutra, please stand up. An affidavit deposed to by yourself has been handed by Mr. Impofu on your behalf in support of your application to be limited on bail in this matter. In the affidavit, just after paragraph 20, actually in paragraph 21, on page 5, you disclose that you have no previous convictions and no other charges, pending charges against you. I am obliged to caution you that it amounts to a criminal offense to give incorrect information regarding your previous conviction in any country and or pending charges. Do you confirm that that information in your affidavit is indeed correct? Thank you. I am also obliged to warn you that this affidavit, the content of this affidavit, the facts that you have alluded to in support of your release on bail may be used as evidence against you at any possible trial. Do you understand that? Do you still wish this affidavit to be handed in as evidence? You're okay with that? Thank you very much. You may be seated. For the purposes of record, the affidavit by the applicant Duduzile Zuma Sambutra, consisting of some 9 pages, together with the notice of motion making 10 pages, is marked Exhibit A.
This is the court.
Mr. Impofu, there is one technical matter. Under regulation, I think it is 3 or 5 of the regulations under the Commissioner of Courts Act.
Courts Act, yes.
Yeah. The Commissioner of Courts must put their full names and their full business address. It is a technical thing. So I see there is a stamp, but the full name appears not to be here, although the force number is here.
Yeah, yes, Your Worship. We did deal with that actually when the statement was being made, and we were assured by him, it was a him, that the stamp, insofar as it indicates the place, I mean, it's a broad place because it's letter, is normally sufficient. But Your Worship is quite correct.
So are you requesting that I condone that in view of the stamp?
That's correct.
Thank you.
Your Worship, while I'm
Mr. Yoni, no objection to that?
No objection.
Thank you. Thank you, Mr. Impofu.
Thank you, Your Worship. While I'm on my feet, Your Worship, would kindly request the court to order the media in the event that the statements, these days, these things go around, that the parts that were not read out in court should not be published.
Thank you.
That's good.
Mr. Bindu, no objection to that?
I have no objection to it, Your Worship. We have likewise been very careful not to include in our affidavit certain pertinent information which the investigating officer has, but to just allude to them as you will see. But I have no objection to the suggestion made by my colleague.
Can I make that ruling now?
As the court please.
As court, please.
Thank you. It is hereby directed that the media in all its forms is not to publish the addresses disclosed in the applicant's affidavit in support of the release on bail marked Exhibit A, as well as the names and ages of their children, which when Mr. Impofu had read out the affidavit had omitted those parts for the reason that it is not to be published. As I've understood that, because it is because of the security concerns, it's in general, nothing specific. So it is hereby directed that the addresses disclosed of the applicant in Exhibit A And I see there are some addresses in it, in the affidavit of the investigating officer as well.
Indeed, that will also apply to that affidavit.
Yes, in paragraph 8, a similar directive would apply in terms of the addresses disclosed in the investigating officer's affidavit, which is yet to be read and handed in as evidence. So there shall be no publication address. Mr. Mfufu, is that the case for the applicant?
As God pleases, Your Worship, that is the case for the applicant. And Your Worship, in our respectful submission, the onus has been discharged. There are certain maybe remarks that one could make from the bar, but Your Worship is aware of the issues of presumption of innocence. Maybe one that needs particular mention, Your Worship, is that the case, obviously, when the trial starts, which is not mentioned in the statement, will also involve issues of Section 16 of the Constitution, freedom of expression. Your Worship knows that that provision of the Constitution obviously has an exclusion, which relates to so-called incitement of imminent violence. So, but those are debates that will be had at the trial. But that's one. Those are some of the, if you like, self-evident exceptional circumstances which arise from the law. If my learned friend has no objection.
Yes. I will give you an opportunity to elaborate on conclusion of the entire incident. So we let the state continue now,
yes,
and then you can address me and make submission.
Yes, subject to that, then, Your Worship, that is the case for the accused, as God pleases.
Thank you, Mr. King.
Thank you, Your Worship. Your Worship, the investigating officer has likewise made an affidavit for presenting to the court information that will assist the court in determining the bail issue. With the leave of the court, may I read into the record? The copy was handed to Your Worship in chambers. The investigating officer, Pegikaya Nazu, states under oath in English, I am a colonel in the South African Police Service attached to the Directorate of Priority Crime, Directorate for Priority Crime Investigation, Serious Organized Crime Investigations, KwaZulu-Natal. The facts contained herein, unless otherwise stated, or the content indicates otherwise, are within my personal knowledge and are to the best of my belief true and correct. I am not opposed to the accused being granted bail herein. The accused is facing 3 charges. Count 1, contravening Section 14D, read with Sections 1, 15, 16, 17, 18, and 19 of the Protection of Constitutional Democracy Against Terrorist and Related Activities Act 33 of 2004, and further read with Sections 94, 256, and 270 of the Criminal Procedure Act. Further read with Part 1 of Schedule 2 of the Criminal Law Amendment Act 105 of 1997. The second count is contravening Section 18(2)(b) of the Riotous Assemblies Act 17 of 1956, read with Sections 94, 256, and 270 of the Criminal Procedure Act. And count 3 is incitement to commit public violence, read with Section 17 of the Riotous Assemblies Act 17 of 1958, and read with the other relevant sections that I have mentioned earlier from the Criminal Procedure Act. I was mandated by the provincial head of the Directorate for Priority Crime Investigations, KwaZulu-Natal, to investigate the civil unrest, large-scale violence, and widespread looting in KwaZulu-Natal in July 2021. The above-mentioned unrest and public violence followed the incarceration of former State President, Mr. Jacob Zuma, with regard to the ruling of the Constitutional Court in respect of the application brought by the Zondo Commission of Inquiry into State Capture. I am part of the team in KwaZulu-Natal that was comprised to investigate allegations of incitement, orchestration, instigating, commanding, counseling, influencing, and aiding and abetting, encouraging, instructing, and influencing a specific sector or the general public of the Republic of South Africa to commit crime, the result of which, sorry, that's awkwardly written, the result of which was riots, unrest, public violence, and large-scale damage to essential infrastructure and businesses, loss of life, fear instilled into the general public. Several social media posts were made demanding the release of Mr. Jacob Zuma and were directed to the judiciary and current President of the Republic of South Africa. These campaigns and social media posts called for the shutdown, particularly in the province of KwaZulu-Natal, forceful closure of national roads, shutdown of the economy, and large-scale extensive damage to property, threat to human life, and nationwide public violence. An affidavit of the complainant alleging that there was evidence to suggest that Ms. Duduzile Zuma Sambutla had committed, amongst others, the acts of incitement of public violence, incitement of malicious injury to property. These were allegedly committed by unlawfully and intentionally publishing words likely to persuade, provoke, or to urge persons to violence, or producing imminent criminal offences likely to incite or produce the offences mentioned. This she did through her social media account. Further investigations support the allegations by the complainant. Paragraph 6 contains the addresses of Ms. Zuma, which were verified by the investigating officer, and he concludes that she has at least 4 bank accounts. We have the numbers in our position, Your Worship, but I have deliberately not put them into the affidavit for security purposes. She is known to be married to Mr. Lonwabo Sambul. There is no information suggesting that she is a flight risk, and it is signed and commissioned as is required. Your Worship, with the leave of the court, may that be included in the evidence as Annexure B.
Mr. Kofi, you had sight of it, of the investigating officer's affidavit.
Indeed, Your Worship, I have.
Thank you very much.
Let's go, Mrs.
Thank you.
The state will not lead any further evidence.
Yep. The affidavit by the investigating officer being Nazo is marked with B.
Let's go.
As the court pleases. That is the state's evidence as far as bail is concerned. I will address Your Worship if necessary on any other issue.
Thank you very much, Mr. Important. Any address on any matter you think is relevant with any information for me to exercise my discretion?
Thank you, Your Worship. I'm indebted to Your Worship. Yes, Your Worship, in our respectful submission, the affidavit sufficiently addresses the requirements of the law. In particular, as Your Worship well knows, that in addition to the so-called ordinary circumstances, flight risk and the usual, in terms of section 6011A, the accused person also bears the extra onus of establishing exceptional circumstances. In our case law, to paraphrase Your Worship, it has been said that sometimes even so-called ordinary circumstances in a particular case become exceptional. So what we have done is to set up what I would refer to as the ordinary circumstances, but separately then set up the exceptional circumstances. But from Your Worship's point of view, Your Worship would implore the court to view those circumstances holistically. In that regard, then Your Worship, you are of the view that the onus has been discharged. Particularly, as my learned friend indicated, there has been a very cooperative relationship between us and the state, and so indications were already made informally even before we got their affidavit about the attitude of the state to bail. The only other issue, Your Worship, just for the record, is the contextual constitutional setting that I referred to. As I said, that we would implore Your Worship to keep in mind in assessing the evidence before you that contextual setting, which is characterized firstly by the presumption of innocence. I don't need to elaborate as to the implications of that in respect of bail, but as I said, more specifically, the very worrying issue about freedom of expression. to the extent that it is common cause that this entire case is really founded on expressions made by the accused on social media. And as I said, Your Worship, we do acknowledge that there's no such thing as freedom of expression to do anything, and therefore that is why this is Section 16(2) of the Constitution. But Your Worship, in our respectful submission, there's no suggestion that that section applies, but that's a matter that will be debated hopefully at length during the trial itself. Other than that, Your Worship, there's nothing more to add. We would therefore implore and pray that the court grants bail to the required amount.
Thank you, Mr. After this addressing this aspect,
Yes,
as I've considered the affidavit and the submission so far, the applicant was arrested. And I do understand and appreciate that there was a degree of cooperation, a substantial degree of cooperation between yourselves and the state.
that's correct.
But my issue is that this, reading the affidavit, it seemed that these relate to an incident the July 2021
That's correct.
and that the investigations would have commenced not long after that, it seems.
It's naturally, Your Worship.
So we down about 3 years and 7 months or so, or 4 years as we put it, just short of 4 years.
Approximately, yes.
Yes. So why, what occurs to me is that why was the accused arrested? If the state has made various submissions that she's not a flight risk, in fact, it's all positive submissions made by the state that this has been verified. I'm just a bit concerned, and I want Mr. Gendia to address me on this aspect. Why was it necessary to secure her attendance at court by virtue of an arrest? If all these factors which are favorable to the accused, not your flight risk, member of parliament, and then so many years have passed since this incident. Yes, I could just hear you very briefly on that.
Thank you. Your Worship, indeed. Well, let me just say, Your Worship, maybe to preface the response to your question, that the entire business of this case is rather bizarre, particularly in relation to the length of time that it has taken, as indicated in the statement, simply to inspect what are 4 or 5 or whatever number of social media posts. Surely that's not an exercise that should take even 4 hours, let alone 4 years. But be that as it may, Your Worship, we appreciated that for whatever reasons, legal and illegal, depending on what will be found by the High Court when those issues are explored. The state saw it fit to succumb, for lack of a better word, to some pressure either from the complainant or other protests by doing what it did 4 years later. But on the specific issue of the arrest, Your Worship, I must say that maybe in favor of the state, that particularly given my own interactions for the past 10 days or so with the investigating officer, Colonel Nazo, and then subsequently my learned friend, as Your Worship has remarked, the attitude has really been professional. The matter has been handled professionally. So without putting words into the mouth of my learned friend, I would assume that the issue of the arrest per se was really for procedural and technical purposes. And for what it's worth, I was present throughout the procedures, even the fingerprinting procedures. And there was really, it was a matter of, in fact, our terminology was that it's processing. But I suppose, to be technically correct, one could say that there was an arrest. And as indicated by my learned friend, the accused cooperated throughout the period. So we really don't take much issue with that. There was, as far as that is concerned, that was not a particularly onerous provision. But I must qualify that, Your Worship. That is not to say that were not seriously, that the accused is not seriously aggrieved by the prosecution itself. So we don't want one day somebody to say, oh, but you said it was all fine. No, it's not all fine. Even the comfortable arrest and processing was uncalled for. This whole thing is just a waste of the state's time and everybody's time. That will be our attitude at the court.
Thank you, Mr.
Thank you. Your Worship, I'll deal with the issue of the accused being brought to court under arrest as it has happened. Your Worship, the nature of a charge that an accused is charged with determines the schedule in which bail applications are heard. And the schedule in which a bail application is heard brings about different things. If it's Schedule 5, there's a different onus to be dealt with, and Schedule 6 has a different onus. Now, in Schedule 6, the onus rests upon an accused to do so. In this case, the accused is charged with the Schedule 6 offense, as we've agreed. Now, when it comes to the bail process is an inquisitorial process by the presiding officer. Ultimately, the decision to grant bail or not rests with the presiding officer. Even if the state is not opposed to bail for an accused, the presiding officer can say, nonetheless, I find that you have failed to discharge your onus of showing exceptional circumstances exist in the interest of justice, and therefore refuse bail. Now, Your Worship, a court cannot make that consideration for an accused who is brought before the court who is not under arrest. A court can only make that consideration when an accused is brought under arrest. If an accused is brought here by summons, we then deprive the court of the right that it has, of the duty that it has, to make that inquisitorial finding regarding bail. And so, what we then chose to do, and that is to secure the attendance of the accused in the circumstances of a Schedule 6 case with in the least imposing way on the accused. And that was to do it as we did. We phoned the accused through her legal representatives. We made arrangements for her to be brought and to be placed formally.
You don't have to address me on that. Already been
All right.
addressed. That seems to be
Thank you.
court. It's just that when all these favorable circumstances are present, and the rest is just a manner of securing the presence of the accused in court. And generally, as a general constitutional principle, the least restrictive manner of securing the attendance of the accused in court should be invoked. And given the length of time, 3.5 years, or 3 years and 7 months, in view of what the state itself has submitted, not applied to all those favorable circumstances, why couldn't a summons be issued? Would that not have been acceptable in these particular circumstances?
Indeed, Your Worship, one could issue a summons and an accused would have come to court.
Yes.
But the problem is, we are now having a scenario where we, as the state, would have preempted the magistrate's decision regarding bail. Because if the accused had arrived here under summons, and let's say that it was Your Worship's contention that no, we should not grant a bail, how would Your Worship place her under arrest? You don't have the right to place her under arrest in those circumstances. So the most convenient way then to bring her to court and to place her before a presiding officer who will determine her freedom of movement after a bail application was to secure the arrest in the least restrictive way, which is what we did.
Thank you, Mr. Kennedy. Yes.
Your Worship, I can assure you that as the state, and my colleague will confirm, every step was taken to ensure that the least restrictive means of securing the accused attendance at court today was employed.
Yes,
there was
that's
cooperation
common
throughout.
cause.
Yes,
Yes, it is
right.
common cause.
On the issue of arrest, we did contemplate. I'm just backing to recall the case law, but there is case law that deals with this issue. We did contemplate issuing summons at some point, and then we were guided by the fact that if we did that, we would deprive your Worship the opportunity of determining the bail issue. And so therefore we have done it in this manner and with the least inconvenience to the accused.
So it was done for the convenience of the court?
No, Your Worship, it was done so that we didn't deprive the court to exercise its duty as far as bail is concerned.
Thank you, Mr. Kennedy.
I see that my colleague might want to address you.
In reply, yes. Thank you, Worship. Yes, on a lighter note, Worship, it looks like it was the fault of the court that the arrest was made. But no, Your Worship, on a more serious note, we do concur with the remarks made by my learned friend. Just for the sake of the record, if you look at the Criminal Procedure Act, Your Worship, as you know, the way it's structured is you have the introductory sections, then you have the arrest, then you have section 50 onwards, you have the bail, and so on. So that's really a chain up until the trial and appeals and so on, section 316. So it's a chain, and I agree with my learned friend that it would seem that it was viewed by the state as necessary to go through that chain for the sake of formality. But without repeating myself, Your Worship, whatever concession we make in that regard must not be read to deprive us of any opportunity to say that both the arrest and the prosecution are unlawful, but not unlawful in the sense of the technicality of whether in the manner in which it was effected. Unlawful in the sense that it's part of something that, in our respectful submission, at the right forum, we will submit was totally uncalled for. And maybe just for the sake of conclusion, to say that A, as indicated in the statement, we hold instructions to bring a case of malicious prosecution at the right stage. But before that, or at the appropriate stage again, we also intend to proceed in terms of section 179 5D of the Constitution, Your Worship, which says that the National Director of Public Prosecutions may review a decision to prosecute or not prosecute after consulting the relevant Director of Public Prosecutions and after taking representation within a period specified by the NDPP from the accused, the complainant, and any other party whom the NDPP considers relevant. So those are the safeguards that we will be taking upon our side. That's correct.
Thank you, Your Worship. So that I may continue. I will deal with section 179, which my colleague referred you to now, that he intends to approach the National Director to reconsider the decision to prosecute. Your Worship, any charge brought in terms of Tadara has to be approved by the National Director of Public Prosecutions. And this charge that we brought against the accused, one of the reasons for a slight delay, and I'm not blaming the National Office, I will explain that now, was that the matter had to be referred to the National Office, and the prosecution against the accused is authorized by the National Director of Public Prosecutions. I will present the original authority when we reach the trial stage, but indeed it has been approved. Now Your Worship, my colleague mentioned to you, and there's just three things that I want to address very quickly. He mentioned to you section 16(2) of the Constitution and the right to freedom of expression. Now, I'm just going to deal with that very briefly by saying that everybody has a right to swing their arms, but somebody's right to swing their arms stops where someone's nose starts. And so every right to freedom of speech, to freedom of anything is limited. And so, Your Worship, no one has an unfettered right to do as they please. The evidence has been collected. There is a very strong case against the accused. The process to bring this matter to court, it has been dealt with, and the decision was made by no less than 12 to 15 senior state advocates and deputy directors. It was not a decision that was taken lightly, and it is the reason, one of the reasons why the decision took a little longer to make than others. There are other reasons, and I'll deal with those very quickly. My colleague seems to suggest that there was no successful prosecution of this type of case, which is not true. Duduzile Zuma, who was responsible or instigated or incited the burning of Brookside Mall, was convicted and sentenced to 12 years imprisonment. And the circumstances of that case was very similar to this one. Mr. Zuma, in his matter, posted on social media certain suggestions to people encouraging violent activity. So it is not true that there were no successful prosecutions of unrest matters.
But I wouldn't know that, Mr.
Indeed, Your Worship, I'm dealing with in
Yeah,
response.
Yes, I'm saying in paragraph 7, the only evidence that has been disclosed to me is an affidavit by an unknown, as far as we are concerned, complainant, alleging evidence to suggest that the applicant has committed, amongst other things, acts of violence or incitement to commit violence.
Indeed, Your Worship, I'm addressing the issue that the state has a weak case, and I am saying to you that we successfully prosecuted a similar case. One, we've considered the facts in this case, and we believe that we have a strong case. Let me stop my submission on that day. So to say that the state has a weak case is not a given fact.
Yes, but I'm saying I'm unable to make any ruling on that, in the sense that the only evidence implicating the applicant before court is you made mention of an affidavit by a complainant, and then it concludes in paragraph 7 of Exhibit D. This she did through her social media account. Further investigations support the allegations by the complainant. So as far as this court is concerned,
I appreciate that.
I don't know exactly what the allegations are.
I take Your Worship's point, but as long as Your Worship is aware that there were further investigations and they supported the allegations. Your Worship, with regard, the one issue that I feel that I must address now is the suggestion that the prosecution is malicious and that it is politically motivated somehow. Your Worship, I'm at the tail end of a very long career in prosecution. I can simply say that if there was any political interference in this matter, I would have been the first one to expose it. Your Worship, other than that, I have no submissions. My affidavit and my colleague's affidavit deal with the issues pertinent to bail, and if there's anything Your Worship wants to inquire after regarding the issue of bail, I have no submissions to make.
The amount of bail that seems to have been agreed or suggested was 3,000 rands. In view of the peculiar circumstances, I say peculiar because everything in this case is positive. I'm not even possessed of even prima facie evidence. I'm relying on the say-so of the state that a complainant made an affidavit. Why should I even fix bail in this matter? Because the amount of bail should serve as an inducement for the applicant to stand her trial. And given all the circumstances in this case, is 3,000 rand really going to serve that purpose? Is it necessary, first of all, and is it going to serve any purpose?
Your Worship, the suggestion of the amount of 3,000 rand came from my colleague when we talked on the phone yesterday, and I actually laughed at the suggestion and I said, given the means that the accused has, 3,000 rand would just be worth walking away from quite easily. The amount is in Your Worship's discretion. As I've said, I have no further submissions to make. 3,000 was proposed by my colleague, and we accepted that as a reasonable amount to be.
I'm saying, bail cannot be imposed symbolically. It must serve a purpose, particularly the amount of bail. And it seems in this case, it doesn't serve any purpose to fix an amount. That she cooperated, she knew of the investigations at least 2 years ago, according to the state. She's not applying this. In all those factors.
Your Worship, I think that my colleague was guided and I conceded to that amount because it was the standard amount that was imposed on all other persons. But I appreciate what Your Worship is saying, and ultimately the decision is in Your Worship's hand.
No, thank you for your candidness.
Yes, yes, thank you, Worship. Just a few matters of reply for the record. Your Worship, my learned friend maybe misunderstands what I was saying about Section 179 of the 179(5)(d) of the Constitution. Of course, notionally, Your Worship, we all know as lawyers that notionally all prosecutions are authorized by the National Director of Public Prosecution through delegation or directive. That's not the point. The point is that that has never deprived any citizen of South Africa or any person for that matter for invoking their rights in terms of Section 179(5)(d). But I'll leave that there. Because what we should refrain from doing, Your Worship, is to have all those skirmishes here. Those skirmishes will be done at the appropriate forum. So even to the extent of whether the prosecution is malicious or politically motivated, that is not a matter that can be debated here. We're certainly not accusing my learned friend of being the politician behind this. So if in the unlikely in his version that there was such interference, it would have been at a much higher level anyway. The third point, Your Worship, is that the issue of that this matter had to occupy the services of 12 to 15 senior state advocates, just to read Twitter messages, speaks for itself as to the wastage of state resources in this country. But be that as it may, the statement about, I want to just say a few things about paragraph 7, I think, of the issue about
Exhibit B.
Exhibit A. Yeah, I'm sorry, I'm on Exhibit A.
Exhibit A, yes.
Yeah. Oh, no, it's 26.6. Your Worship. That statement must be right. First, I want to make two remarks here. The accused person says the following: to the best of my knowledge. In other words, to the best of her knowledge. So I don't know why it's attributed to me. No other person who has been charged with the same or similar offenses has ever been convicted. Some have been either acquitted or have had their charges withdrawn. So the fact that a certain Mr. Zuma was convicted for whatever that Mr. Zuma, the accused does not know all the Zumas in this world. So that Mr. Zuma might have confessed, might have, we don't know. Your Worship is not, and Your Worship's conclusion with respect, that's why I don't want to elaborate, was correct. But on these papers, Your Worship cannot then say, well, this statement, firstly, it's qualified to the best of her knowledge, and secondly, we don't know what the circumstances of that other case were. She can also come equally with examples of well-known people who have been acquitted on similar charges, and we don't want to get into that unnecessary ping pong. Now, the next yes, those are our submissions, Your Worship, because the purpose of Your Worship today is very simple. It is not to delve into the merits, only insofar as they impact on the issue of bail, and Your Worship has made that clear. The last issue, Your Worship, is the issue of the amount. It's not strictly true that this was proposed by the accused. What actually happened is the following: that in a discussion that we were having with my learned friend, they were suggesting a higher amount, let me just say that, a much higher amount, and our stance was therefore that well, and I'm paraphrasing the discussion. Well, if you are going to fix an amount, then it cannot be more than that has been fixed to other similar accused. And in fact, my learned friend even said, well, but she's not the same. And I said, well, are you really, is the state's position that she's going to be treated differently from other people? And after that, then the consensus was reached. But without what is known as snatching at a bargain, we agree fully with your worship that and my learned friend, this is a matter that's entirely within the discretion of the court on the totality of the facts before you. And on the totality of the facts before you, it cannot be denied that the amount is at best symbolical. And therefore, if your worship is not in the business of symbolism, then your worship is at large to fix a low amount or no amount at all. That's the purpose.
Thank you. Mr. Mostly, just one aspect
Escort.
is the evidence against the applicant at this stage, just on a prima facie level.
Yes, yes.
I cannot just accept the say-so of the prosecution without something being there.
Absolutely.
So do we know at this stage, even on a prima facie level, what are the allegations that informs the charges as they are currently framed?
Thank you, Worship. Your Worship, as indicated in the statement, I think it's part of where she talks about statement of facts. Oh yes, paragraph 5, Your Worship. Although I have not yet had sight of the complaint or the summary of facts, I am aware of the long-standing rumors and innuendos and so on. Your Worship, that's a very critical question that Your Worship has raised. Your Worship is totally correct that the only thing in front of this court is that there is an unnamed complainant somewhere. Just from the bar, I would say that yesterday I heard in the news that there was some person who claimed to be the complainant. I don't know how far true that is. From our point of view, and that person is Mr. Paul O'Sullivan. But from our point of view, we have not yet, Your Worship, received the docket or any document. In fact, even the charge sheet, my learned friend kindly took photos and sent it to me yesterday, just so that we could complete the affidavit. But as a matter of time, Your Worship, there is absolutely nothing except messages which are still on Twitter, by the way. Everyone can read them. It's not like she just then went to delete them. Those messages have been there for 4 years, and as we indicated, the most dangerous thing said in those messages is, I see you. So,
but I'm asking this question insofar as it pertains to the application for bail. I understand the due processes where the accused must be informed with sufficient clarity to adequately prepare defense. But I'm referring now to the matter before.
Where we are now.
Yes. So there doesn't seem to be, beside the say-so of the complainant, we don't know exactly what are the allegations, and the state seems to be linking
social media posts.
Yes. We have disputed any causal or other link, etc. So for the court assessing the bail, what prima facie, if any, evidence do I have before me implicating the accused?
None. You have none, Your Worship. In fact, on the contrary, you have exculpatory statements from the accused. Without, if you were talking about the notional scales of justice, so on the one side of the scale is the exculpatory statements, on the other side of the scale there's nothing. That's good.
Thank you, Mr.
Your Worship, if I may, on the issue of the prima facie case, refer you to paragraph 7 of the investigating officers. We are not here, Your Worship, to present the merit of the entire state case. We are here, Your Worship, to secure the attendance of an accused at court and to demonstrate that we do have a case, a prima facie case. Paragraph 7 clearly makes it that there is an allegation by a person that deals with certain offences that may have been committed, and then the last line says, further investigations support the allegation. And so, that is clearly a suggestion that we have secured evidence through investigation that support the allegation that she unlawfully and intentionally, by publishing those words, committed the kind of inciting public violence. So that issue of prima facie that Your Worship seems to be on Your Worship minds, in my view, is addressed by paragraph 7.
Do you think it's adequately addressed for the purposes of the bail application?
In my view, it is adequately addressed.
Sorry, I'm not suggesting that there is unreliable, insufficient evidence before me to make a ruling. But in almost every bail application, one of the considerations that the court must take into account among various others is about 72 enumerated under Section 16, is that there must be prima facie evidence implicating the accused in the commission of the offence that has been referred. In other words, not just a mere say-so.
Respectfully, Your Worship, as I said, we haven't listed every single item we will rely on, but paragraph 7 makes it clear that we believe that there's a prima facie case, which is why we are here.
Thank you, Mr. President.
Your Worship, maybe just to be helpful to the court.
Yes.
Your Worship, and maybe to assist my learned friend. The question that Your Worship is really asking has to do simply with the bail application.
Yes.
And the simple answer is the following, which I thought my learned friend would give. Your Worship, of course, has the wide latitude to take into account various factors. One of those factors in the appropriate circumstances, and this was held in a case called Francis and another case called S versus Jonas. One of those circumstances might be the strength or weakness of the state's case. Now, in my understanding, that's not it's not something that Your Worship has to deal with. But if it is raised, Your Worship is quite correct, then it may be one of the factors. And it would seem that from what Your Worship's remarks are, in this particular case, that factor can play no role because Your Worship has not been placed with anything to find one way or the other. That so whether the case is strong, as my learned friend claims, or that I say it's weak, as we say, and therefore that is not a factor that will play any role in the determination made by Your Worship. Let's go, please.
Thank you. Just one other aspect, is the matter still going to be postponed for further investigation?
No, Your Worship, the investigation is complete. My colleague and I have agreed that the matter, and I have an indictment to serve upon the accused once we've determined the issue of bail, and the matter will be transferred to the High Court for the trial date to be set. The investigation is complete, Your Worship. The date we have agreed upon, Your Worship, is the 20th of March for a first appearance in the High Court. We will thereafter set the matter down through the High Court processes for a pre-trial conference.
Is that the Durban High Court?
Durban High Court, Your Worship. I do have the indictments which must be served upon the accused with me, if Your Worship, once Your Worship has decided on the nature of
the
it.
indictment and the summary of the substantial facts.
Yes,
Of witnesses, days out.
indeed, everything.
Mr. Info, that date is suitable.
The date, I confirm the date, Your Worship, and the transfer.
Your Worship, with regard to the docket itself, I have made arrangements with Mr. Mpofu to send it to him electronically as soon as he provides me with contact detail to send it to.
Yes, but procedurally you will serve it on the accused.
Not the docket, the indictment, yes.
Yes, the indictment.
Yes, no, the indictment on the accused. I'm talking about the docket, Your Worship, so that my colleague has the case information so that he can prepare for the High Court proceeding.
Thank you. Thank you. Extemporary ruling of judgment on the application for bail. This is an application by Ms. Duduzile Zuma to be released or remitted on bail pending her trial, which I've just been informed will take place in the Durban High Court. For purposes of expediency, I will not repeat or reread all the entire content of the parties' affidavit, but I will just refer to those aspects I consider pertinent for exercise of my discretion insofar as it relates to bail. The applicant was arrested this morning, and in terms of arrangements made with the defense, was brought to court. It is common cause that this is an application for bail to be dealt with under Section 1611A of the Criminal Procedure Act 51 of 1977. The parties are highly identical of like mind in that regard. I am also satisfied having regard to the charges as they have been framed in the charge sheet, particularly in respect of count 1 relating to the protection of constitutional democracy against terrorism and related activities, Act 33 of 2004, referred to as, or I will refer to it in short as Pakatara, that the offences do indeed fall within the ambit of what we commonly refer to as Schedule 6. In terms of Section 6011A, an accused person faced with an offence which falls within the ambit of Schedule 6, the law provides that such person shall be kept in custody until given a reasonable opportunity to adduce evidence to satisfy the court that exceptional circumstances do indeed exist, which, in the interest of justice, permits the release of the applicant on bail. Since the amendment to the bail legislation in 1998, there are literally hundreds, if not thousands, of cases dealing with the issue of Schedule 5 and Schedule 6 bail application. When the Section 6011A and B was promulgated, it was done so by Parliament in order to control serious and violent crime. And its intention was never to deny a person charged with a Schedule 5 or 6 offence the opportunity to be released on bail. Rather, it made the bail provisions less liberty-orientated rather than totally. So it is not impossible. Mr. Impofu has submitted that usual circumstances that one meets in every bail application are indeed, or could indeed be exceptional. When I consider the issue of exceptional circumstances, in addition to the various cases by the Constitutional Court, State versus Samini and the other cases in 1999, the cases by the Supreme Court of Appeal and the various divisions of the High Court, what is clear is that it should be something out of the ordinary, and ordinary circumstances would be sufficient, but if there are a whole host of circumstances considered cumulatively, there may be circumstances which individually may meet that requirement. But in this case, I'm also struck by the state, who have no objection to your release on bail. They have placed on record as they obliged to the reasons, therefore, all your favorable circumstances, coupled with the attitude of the state in not objecting to your release on bail, I am satisfied it crosses the threshold of proof that there are indeed exceptional circumstances which are present. The reason why I inquired from both counsel regarding the arrest as a manner of securing your attendance at court was in view of the whole host of favorable circumstances, even submitted by the state itself. There is nothing in the affidavit of the investigating officer to even remotely suggest that there would be any risk in releasing you on bail. There has been no conditions that have been submitted, and I don't think I could, but I don't think in this case there are any reasons or basis for me to impose any conditions on you with regard to your release on bail. There was exceptional circumstances which I considered in terms of Section 16, I think it is subsection 4 of the Criminal Code. It must meet the requirement of the interest of justice. And the interest of justice is a value judgment that the court takes into account having various, or taking into account various factors enumerated by the legislature. So the legislature has gone to the extent of prescribing what is not in the interest of justice. For example, if you were to interfere, there's a likelihood that you would interfere with state witnesses with investigation. But there is a total absence of any such factors or circumstances which have been placed before me. So I accept that your whole host of favorable circumstances, coupled with the attitude of the state and whatever you disclose in your affidavit, those exceptional circumstances do, in the interest of justice, permit your release on bail. I am also obliged in terms of Section 60, subsection 9, to take into account a whole host of circumstances and factors. For example, the need for you to consult with your legal representative. When is it likely that the matter would indeed proceed to trial, if it does indeed proceed to trial? These are all factors which the legislature has enumerated that the court must take into account. So considering the matter holistically, I am satisfied then that those exceptional circumstances do in the interest of justice permit your release on bail. Regarding the, just on those factors, if I may just mention that the bail legislation, one is, it's not geared towards making factual conclusions, but when they amended the bail legislation in 1998, it was designed for the courts to make an informed prognosis of what is likely to happen and not happen. And in view of all the circumstances placed before me, I can see nothing negative in releasing you on bail. The amount of 3,000 rand was suggested. I think, although not directly implicit in the submissions by the state, is that perhaps it has some degree of symbolism attached to it. I don't think the court should be in the business of making orders which are symbolic. We should be dealing with the matter as the facts appear before us and having invited the parties to make a submission beyond. I therefore will be trying to fix an amount of bail. In terms of Section 72 of the Criminal Procedure Act, I think all the circumstances in this case point to you being released on warning in terms of Section 72 of the Act.
As the court pleases, Your Worship.
Yes, please, Mr. President.
Your Worship, I have an indictment which needs to be served upon the accused. The date for transfer to the High Court is 20th March 2025. Yeah.
Have you said that on the report that the subcommittee?
Thank you, Your Worship. Your Worship, it's the other one that goes. Ask. Can I ask? Can you please serve it on the accused?
So for the purposes of record, the indictment, which include the summary of the substantial facts consisting of 5 paragraphs and the list of witnesses, is marked Exhibit C.
As court please, Your Worship.
Confirm, or Ms. Zuma Sambuddha, do you confirm that you received the indictment? Okay, and it contained the summary of substantial facts and the list of witnesses. Thank you very much. I confirm that it has been duly served. And don't we have a notice of trial as well when we served?
The notice of trial is attached to the copy that was given to the accused. Your
It's
Worship.
not on this copy?
Not on that.
Okay. So, Ms. Zuma Sambuddha, the matter is transferred to the Durban High Court, which is currently just housed in the opposite end of this building. I see there's no court specified, but I'm sure Mr. Import will assist in that regard. For the 20th of March this year, at 8:30, the matter is being postponed as a provisional date. So, depending on what happens, and the matter will then be adjourned either for a pre-trial and then a trial, but depends what happens. But please report to court at the Durban High Court on the 20th of March this year at 8:30. Should you fail to appeal, a warrant for your arrest will be authorized, and you may then be kept in custody pending finalization of this matter. Do you understand, Ms. Zuma? Do you understand? Thank you very much. Is that all, Mr. Import?
Your Worship, I'm afraid there is just a small matter. The Worship, yes, we've just now been served with the indictment,
Yes.
and I know that the decision on bail has been made, Your Worship. But since this is a matter of public interest, I would like to remark on the fact that this so-called terrorism charge, Your Worship, seems to be out of sync with what my learned friend says was the complaint. According to him, the complaint was as incitement to public violence and the incitement to malicious injury to property. So it's just to say, Your Worship, once again, at the appropriate forum, it's the issue of malice will be dealt with, because it's not clear now where the terrorism came from. It seems to be just a need to create drama and to elevate this to a Schedule 6 offense artificially. And I'm not, again, accusing my learned friend personally, but as a matter of concern, it has to be said that this whole business smells with something fishy.
I think there's issues, Mr. Gambia. You intend to bring make representation to the National Director.
Yes.
Although it has been authorized by the National Director, we obviously know that when representations are made, it includes representations by the accused, as opposed to just considering the state's case. So that's always at your disposal, but it can be sorted out in due course.
With respect to Your Worship, I think that I have the right to reply to a certain submission by my colleague that these things were escalated. Your Worship, sometimes a complainant may make a charge and say, somebody has come to my house and done a certain thing. Further investigation revealed that he had a firearm in his possession. It doesn't mean we can't charge him for the firearm. The complainant said one thing. The investigation revealed that it was an act of terrorism, and that is why there's a charge there. I think we mustn't now try, because the media is present, to play games.
I understand, but I think what I've suggested would be the idea to make those representations.
Who accept that?
Yes, thank you very much. All right, thank you, Ms. Zuma Sabuta. 20th of March, Durban High Court, Kapase, Division 1. I'm indebted to all of you that work with the short.
When the